I'm Tom Wolf. I'm counsel with the Democracy Program at the Brennan Center for Justice. I spend most of my work hours and most of my post-work hours, and sometimes even my dreams and nightmares, thinking about partisan gerrymandering litigation. This is a very busy time for gerrymandering litigation. Sunday morning TV, the newspapers, Twitter, they've all been abuzz with what's going on, particularly about Whitford v. Gill, or Gill v. Whitford as it's now known, the partisan gerrymandering case coming out of Wisconsin. Now, as I said, I spend most of my time thinking about partisan gerrymandering litigation. And even I, when I read the coverage of what's going on in the courts and the search for standards, I'm left feeling a little dizzied and confused. A lot of the coverage leaves the impression that you need to have a doctoral degree in advanced statistics, or that you need to have some sort of secret complex constitutional knowledge to understand how courts can rein in gerrymandering. If these were movies, the coverage sort of suggests that we're either in a beautiful mind going crazy, drawing on walls with equations to figure out how to unlock the perfect secret, or that maybe we're in the Da Vinci Code or National Treasure and we're like running off to Philadelphia to look at the Liberty Bell to see like what the founding fathers sketched into the bell that you can see at a particular time if the moon is angled just right. But even though the question of how to use the courts to rein in gerrymandering is not easy, I would submit that it's not as complicated as it may seem. And so hopefully at the end of this 20-minute talk, you will think so too. You'll have a better sense of why people are looking for legal standards, why this has been hard, and what's currently on the table. You'll have a better sense of what problems these cases might fix and what problems they might not. And I think most importantly, you'll have a better sense for what makes these cases, these particular maps, unconstitutional. I'm deviating a little bit from the script for two reasons. One is that I'll make my presentation a little shorter so that we can talk about some of the cases later if you're interested. But also there was a moment at oral argument in the Gill case 2 weeks ago when Chief Justice Roberts said to Paul Smith, who was representing the plaintiffs, how will an intelligent person on the street understand our ruling in this case if we rule for the plaintiffs or if we don't rule for the plaintiffs? He actually said intelligent man, but I'll pretend that he said intelligent person. And what I think he's getting at, and I take that question very seriously, is that when it comes time for courts to say why a map is unconstitutional or why it isn't, the standard we're looking for should be something that's pretty basic in a sense. It talks about basic constitutional values that everyone can understand. What I'm going to do is I'm going to basically give a three-part presentation. The final part's going to be a little truncated. I'm going to start with a brief history of partisan gerrymandering standards. Then I'll move into challenges facing standards, basically why this is a tough problem. And then I'll talk briefly, I'll kind of turn the microscope up on the Whitford case to kind of give an example of what I'm talking about. Ben Geffen, who will be speaking after me, and I are having a breakout session at 2:10 in Ballroom C, which will give us an opportunity to talk more about it, any questions you have from things that I've spoken about here, and also to talk about some of the other cases that I might not be able to touch on in the 20 minutes that I'll talk. So moving on. This is a brief history of partisan gerrymandering standards. There's wide agreement amongst justices in the Supreme Court, basically across generations of the court, that excessive partisan gerrymandering is unconstitutional. So if that's the case, then why don't we have standards? It seems like it's super obvious that this is wrong. Why are we stuck? The court basically took 3 runs at this question before Gill, and none of them have really helped people who have been looking to rein in partisan gerrymandering through the courts. The first important case is a case called Davis v. Bandemer. It's from the 80s. In that opinion, the Supreme Court said that partisan gerrymandering was unconstitutional, but the standard they came up with was, they set the bar so high it was basically impossible to satisfy. So they didn't even think that the map in that case was unconstitutional. And no one succeeded in convincing the court after that point to use that standard to rule a map unconstitutional. The standard was glossing on it a little bit, but it's basically that you had to show that the map consistently degraded people's opportunity to participate in the political process. I don't know what that means. No one else really seems to know what that means either, and so it's never really been useful. The second major case is a case from the mid-2000s. It's called Vieth v. Jubelerov. In that case, the court kind of went all over the place. So there were 4 justices who said that this wasn't even the type of question that courts had the ability to resolve. You had 4 justices who said absolute opposite, it's unconstitutional, courts should be involved, but none of them could agree with each other on what the standard should be for saying when a map is actually unconstitutional. Then you had one more justice, because you need 9, and that was Justice Kennedy. He didn't think that the standard that had been offered in that case, or any of the other standards that the other justices offered, solved the problem. But he also didn't want to turn around and say that for all time, this was the kind of problem that courts couldn't be involved in. So he Justice Scalia characterized this as a wait-and-see approach. He basically wasn't ready to give anyone a rule, but he also didn't want to say, we can't come up with a rule in the future. That accounts basically for why when you hear about what's going on in litigation now, everyone's aimed at Justice Kennedy. They treat him as the one justice who hasn't yet made up his mind, and that he's really the one you need to satisfy, and if you can give him something that will work for him, then the other 4 justices will go with him. The third case is a case that's often overlooked. It's a little bit of an appendix. It's normally called LULAC. It came out a year after Vieth. Same fracturing over the question of what to do about partisan gerrymandering. Justice Kennedy made 2 helpful points, though. He said, if I'm going to find a map is bad, it has to be bad for reasons other than just people had bad intent when they were trying to draw the map. There actually has to be a bad effect. And then he clarified maybe a little bit what he meant by a bad effect. And what he was talking about was we need some way to measure the burden that's been inflicted on the people that have been hurt by the bad map. That admittedly is very vague. And so for the next 10 years, people have been working to figure out what exactly it is that we need to do here. How do you measure a burden? What does that mean? What are the limited principles? Is that a constitutional thing? Is that a mathematical thing? Is it a statistical thing? What is it? It's been a great mystery, and I think it's kept a lot of law professors and social scientists employed, because you can write like endless reams of papers just on this subject matter. A lot of which are really good, but there's kind of a lot on the table. So, coming out of these cases, people are sort of trying to solve a couple different problems, because ultimately you're trying to convince the court to do something. You need to know what the court values, what it's struggling with. There are at least 2 major things the Supreme Court's struggling with. One is called the political thicket problem. So as long as there's been election law, courts have been hesitant to dive into issues that seem like they're very political. They have done it in the past, and they've been doing it for a very long time, but there's always like a little bit of caginess and hesitancy around that. Redistricting is kind of like the most political of the political questions. It's seen as something that legislators should really be doing, not courts. And then the second thing is that the court wants to make sure that if it does say partisan gerrymandering is wrong, and here's a standard to attack it, they don't want to have to get involved in every case around the country. So like congressional maps are districted, a lot of state legislative maps are districted, municipal maps of various kinds are districted. There are thousands of potential maps out there. And what the court doesn't want to have happen is for all the federal courts to do from now until infinity is just try to like sort out partisan gerrymandering disputes. So they need to have the confidence that they can go in, but they can kind of go in a narrow way. There's one other problem, though. I mean, there are a lot of problems, but I'd say there's one other problem I would highlight. And that is when you say partisan gerrymandering to the intelligent person on the street, if you ask someone to define that, you might get 10 different answers from 10 different people. So, a partisan gerrymander when the districts are funny shaped? Is it when the maps favor one party too much? Is it when there's not enough competition? Is it when there's too much competition? Is it when you protect incumbents? The list kind of goes on and on and on. That's not to say that any of these individual things aren't problems, but we mean a lot of different things when we talk about it. And so if you want the court, because of this problem about narrow intervention, to get involved, you need to make it very clear what exactly, like concretely, is the problem with the maps that you're asking the courts to fix. And so some of the challenge in the partisan gerrymandering litigation space is kind of like focusing on your problem and making it very clear why that problem is a constitutional problem, and then how you create a standard to attack that problem. So there are now a lot of people have been doing a lot of hard work, and there are a lot of sets of cases in play. We have the Whitford case, which I assume most people are familiar with at this point, out of Wisconsin. There are 2 cases pending in North Carolina attacking North Carolina's 2016 congressional map. One is brought by Common Cause. Another is brought by Campaign Legal Center, which is also bringing the Whitford case. That's going to trial starting Monday. There's also a case that's been pending in Maryland, which is interesting. It's different from the other 2 sets of cases in the sense that it's mainly Republican plaintiffs attacking a gerrymander that favors Democratic politicians. That case was sort of heading towards trial, and it's been stayed pending what happens in Whitford. There are also 2 lawsuits now pending in Pennsylvania, which Ben will talk about a bit more. Ben's representing the plaintiffs in one of them, the Legal Women Voters case. There was also, for a brief period of time, a partisan gerrymandering challenge going on in Georgia, but the court dismissed that claim, so it's not one that I talk about in any extensive length. So my initial plan was to kind of go through the Wisconsin, North Carolina, and Maryland. But what I'm going to do is I'm going to kind of turn the dial up a little bit on Wisconsin. And we're going to talk about that case a bit more in terms of what we mean when we're talking about standards, what the standards are in that case. Okay, but there are just a couple of things I'm going to note before I start, because I don't want the kicker to come at the end. I want it to kind of come at the beginning. First, you're going to notice that Whitford, and I can talk about the other cases later in the afternoon, they're not really about funny-shaped districts. They're not really about competition. Whitford and the other cases are not as math-heavy as you might think. That these cases really are, at their core, really more about principles and values that we get from the Constitution and how to make those real. And the last is that the facts really matter. So when I talk about Whitford, when I talk about other cases, I always start with the facts, because I think in a lot of cases, if you frame the facts right, it's pretty clear what the problem is. And then the legal question is just kind of like the back end of that problem. So Whitford. Whitford is a challenge to Wisconsin's General Assembly map. And basically, here's how that map was put together. In 2010, there was a wave election, which allowed Republicans to gain control of the legislative bodies in Wisconsin. They controlled the redistricting process, and they used that process to draw a map that was favorable to Republicans. How did they do that? They hired a law firm, and the law firm hired a bunch of consultants and legislative aides, and they hooked them up with a secret map room that was off-site. These aides and consultants went to this map room for like 4 months. None of the rank and file Republican legislators that would be affected by the ultimate map were involved in the process until the very end. The consultants worked on a series of maps, and they gave them these code names in terms of how heavily they favored the Republican Party kind of overall statewide. They gave them names like aggressive, like this is the aggressive gerrymander. Then they found a political scientist out of state, Keith Gaddy, who actually ended up filing an amicus brief in Whitford in favor of neither party, but pointing out that gerrymandering is a huge problem. They spoke with this consultant, and what the consultant helped them do is basically figure out not just how would you do under this map under the most recent election, but they actually simulated all all reasonably anticipable election outcomes. So like let's say your party gets 2 more points, your party gets 2 fewer points. How does the map perform? And they settled on a map that was guaranteed to give Republicans a majority, basically regardless of how the vote turned out, like any kind of reasonable vote turnout. And this played out in like a very practical way. So 2012 was the first election. When they turned to the Republican rank and file to show them their districts, they made them sign non-disclosure agreements. And then they basically said, here's your district. I'm not totally clear on all the elements of that process, but I think that fact basically tells you that what really matters is what the leadership wanted, not even what individual legislators in their own party wanted. Democrats, did not even have that opportunity. In 2012, that was the first election under the map. Republicans got something like 48.6% of the statewide vote, but they got 60 out of 99 seats in the legislature. In subsequent elections, they had small majorities of the statewide vote, and they widened their majority in the state assemblies to 63 seats. So basically, any way you cut it, Republicans were going to have a majority. All right, so what's going on here? Basically, Whitford is taking on one type of gerrymandering. It's something that at the Brennan Center we started calling extreme gerrymandering after we released this extreme maps report. And the idea behind an extreme gerrymander is one party uses its control over the redistricting process to grab as many seats as it possibly can and then insulate those seats from turnover over the course of the plan, so for 10 years. That's a particular tactic. Like, that's different from drawing your maps to protect incumbents. It's different from drawing a map so that 2 parties get their fair share of the seats. This is one party trying to get as much as it possibly can get. So they're basically what they're trying to do is they're trying to entrench their power. So why is that wrong under the Constitution? I'd say that's wrong under the Constitution for 4 related reasons. One, we know that the Constitution tells us that we should have accountable legislatures. It's really hard to hold your legislature accountable if one party has a majority regardless of how people vote. 2, the Constitution tells us that we're supposed to have representative legislatures, that these legislatures are supposed to represent the people. Well, in a state like Wisconsin, it's a purple state, it's a battleground state for a reason. When you get all the people in the state together, they have very strong opinions on things that are pretty closely divided. It's like basically a 50-50 state. If you have a legislature that's hard right or hard left all the time, your legislature is not going to be producing legislation, and it's not going to be responding to needs that really correspond to what everyone in the state needs. It also violates the First Amendment, and it violates the 14th Amendment. It violates the 14th Amendment because it doesn't treat all the parties equally. That's one way that the efficiency gap that a lot of people talk about in this case gets tied in, so I'll talk about that a little bit later. It also violates the First Amendment because it prevents people from joining together to form associations, like in this case political parties, to actually go claim some power in the government. Like, the First Amendment exists not just so that we have the ability to speak, but that we actually have the opportunity to participate in and influence the way our legislatures function. So when you ask the question of, well, what is this case about, right? Well, what this case is about is it's about entrenchment. We know that entrenchment is unconstitutional. So then the next question is, how do we know when entrenchment has happened? And this is where the legal standard comes in. So in this case, the plaintiffs are proposing a 3-pronged legal standard: bad intent, bad effect, and then no justification for the bad effect. What's bad intent? Bad intent, they have a more technical way of explaining it in their briefs, but basically the bad intent is you're trying to severely disadvantage another party when you're drawing the maps. The effect is when you manage to act on that intent with a very serious effect. They talk about effects that are durable and persistent. which means that they last for the whole cycle. And the last is that you have no justification for what you've done. Now, then you say, well, the next question is how do you prove? And I'd actually say that a lot of the concern of what's been going on in partisan gerrymandering litigation is less about what the standard is and more about how you prove that the standard's been violated. And there are a couple ways to do it. In this case, the record is pretty stark. A lot of the facts I narrated to you before. You have this messed up process that was fast and it was secret. And we have notes from the legislative aides saying that they designed this to determine who's going to be here from 10 years from now. You have actual election results which show that Republicans maintain a majority regardless of how the vote actually turns out. And then you have these social science metrics that have been deployed in this case and in others. So in Whitford, they rely on two, actually. The main one is the efficiency gap. Another one is called the mean median difference. There's also something called partisan bias. Some people call it Gelman-King bias after the social scientists that invented it. But basically what all of these measures are doing is they're trying to help courts figure out when a map has what's called partisan asymmetry. And all partisan asymmetry really means is that one party has an easier time than others converting votes into seats. So, the efficiency gap, why would you call it the efficiency gap? It's sort of like how efficient is your car? If you put in 1 gallon, do you get 20 miles or do you get 10? Obviously, you want to get 20 miles, you don't want to get 10. What you're doing with votes is basically the same thing. If you have X number of votes in the state, you want to get as many seats as you possibly can for your votes, and you want to make sure the other party gets as few seats as they possibly can. So you can rig the map by cracking and packing people, pushing all the supporters of one party together into one district that they'll win by 80%, or win maybe by 30 or 40%. You're going to spread the rest of your party out so that you're winning every district by like 6 or 7 points. So even if you have the same number of votes, the party that is spread out more evenly in terms of the districting ends up being able to get more seats basically for the same number of votes. That's basically what that math means. Importantly in Whitford, and it's one of the things that makes Whitford an easy case as far as standards in the Supreme Court goes, is that all of those measures, whether it's the efficiency gap, mean median difference, partisan bias, they all tell you that Wisconsin's map is bad. There's no greater mystery. And so to the extent that the court would be concerned about, oh, well, what would happen if we constitutionalize this one measure? No one's asking them to constitutionalize one measure, and the fact of the matter is the outcome of the case is the same regardless of which social science you embrace. Like, they all tell you that the maps are bad. So, to get back to what Chief Justice Roberts said, so he said, and I'll wrap up on this point. So he said, I don't understand all this social science gobbledygook. As the actual term he used was gobbledygook. How are we as the court to be viewed as legitimate when we issue an opinion that would strike down a map? Because what we're concerned about is people are going to say, this is so complicated, there's no way to understand how the court arrived at this. Like, some numbers said, they were over 7% or they were under 7%. That's why they struck the map down. That doesn't make sense to people. What they're going to say is, oh, they did it because they wanted to help Democrats, or they did it because they wanted to help Republicans. My suggestion is that in this case and a lot of the other cases that are pending, the answer is actually pretty simple. Entrenchment is wrong. It violates the Constitution. And the court finally came up with a way to determine when maps are actually entrenched and when the Constitution has been violated. That is sort of the intelligent person on the street's account of why this violates the Constitution.